Lisa here for the state.
Ladies and gentlemen, as I drove into the courthouse this morning, I looked at the sunrise coming up over the mountains. There was a low blanket of clouds covering the sun, making those clouds look golden. It was a beautiful thing to look at and behold as I drove into work today. And I couldn't help but think about the dark night of September of 1986, when Karen was stabbed repeatedly. 45 times she was stabbed. There had to have been a thought between stab wound number 1 and 45 of hope for a new day. There had to have been a thought of somehow being able to survive this attack, to make it to see another sunrise. There had to have been a plea or a desire or a want of mercy to somehow stop this so she could survive. No mercy was shown. Her hope was extinguished, and it was done by the man seated in this courtroom. There's no doubt about that. It's been proven beyond a reasonable doubt. And now, he needs to be held to account for what he did. Now, he needs to be punished. And in making that determination, you apply the law that the court just gave to you, and you make a determination as to which of those possible punishments he deserves. And ask yourself as you go through this process, have we met our burden, the state of Nevada? Because in order for a sentence of death, the jury must find unanimously and beyond a reasonable doubt that at least one, it just takes one aggravator, at least one aggravator has been proven beyond a reasonable doubt. And then you make a determination. Each and every juror determines that the mitigating circumstances or circumstances, if any, which he or she has found, do not outweigh the aggravating circumstances. So you make that determination. We have to prove the aggravation beyond a reasonable doubt. The mitigation does not have to be proved beyond a reasonable doubt. But you have to ask yourself, the mitigation, does it outweigh what's happened? Does it outweigh these aggravators? And then you make a determination, if you make a determination, unanimously, that the mitigation does not outweigh the aggravation. He's eligible for that. So, let's go through that. Aggravator number 1, it's a prior crime of violence. Have we established beyond a reasonable doubt a prior crime of violence? That's the robbery of Frederick Henderson. 1983, the facts in 1983. Late at night, this 73-year-old tourist in town from LA is gambling at the El Cortez. He decides to go up to his room where his wife and the couple that his wife and he came to town with is already up in the room, and the defendant sees him. The defendant preys upon him. The defendant follows him. The defendant gets in the elevator with him. This 73-year-old man, and you heard how he had a cane, and pushes him into the door as he's trying to get into his hotel room, takes his wallet, and flees. Then Mr. Henderson goes to the hotel, and he's able to tell them who this was that did it, and then the hotel knows who he is. Goes and gets him, brings him, and Mr. Henderson identifies him. And ladies and gentlemen, is that something that's been proven beyond reasonable doubt? Absolutely. The defendant pled guilty to it. That's the judgment of conviction. That says, in a court of law, there's a judgment of conviction, a piece of paper that says, he's convicted of robbery. Now, is that a crime of violence? Well, you just heard the judge describe to you what the definition of robbery is. It's taking property by means of force or violence or fear of injury. The testimony that was read in, Mr. Henderson, was pushed down. That's violence. This is a crime of violence. You have a verdict form at the end of your packet there. There's sections 1, 2, 3, 4, and 5. We're going to focus on section 1. That's the aggravation. The establishment of the aggravation. There's the form. There's the one for Mr. Henderson. Check the box. It's been proven beyond a reasonable doubt. The defendant pled guilty to it. And it certainly is a crime of violence. he pushed that old man down on the ground and took his wallet. He went to prison for that, ladies and gentlemen. This whole rehabilitation concept, you heard from the warden, you heard from Dr. Reutman, he had a chance at that. He went to prison. Did he learn from his time in prison, ladies and gentlemen? Did he change his ways? We've heard this concept of changing. He goes to prison, he's released from prison, he's on parole. Just as parole is ending, we get to aggravator number 2. Again, crime of violence. This is the incident, the battery with a deadly weapon against Angela Howell. This is 1986. This is eerily just a little over a month before what happens to Karen. The defendant gets off parole, just barely off parole, and what does he do after he's learned from that rehabilitation process? He goes right back to his criminal behavior, to his violent criminal behavior. And what does he do? He ups the ante. We're not talking about a push. We're talking about a pistol whipping of a woman. She's just trying to get into her car outside of the restaurant she was in to go meet her friends. Taps on the window, points the gun at her. And then he tries to actually tell her to open the door, like she's going to let him in. She tries to keep him out. He tells her, I'll blow your head off. Don't think I won't. It seems like the rehabilitation process is really taken. It's stuck deep inside of him. He's learned. She tries to push the gun away. Please don't do this. Please get out of my car. Begging for mercy. Was mercy shown by the defendant? I don't want to hurt you, I just want your money. Oh, maybe she's thinking, maybe, like that hope for that sunrise that Karen was hoping for. Maybe he'll stop. Maybe if I just give him the money. After she takes her hand off the gun to give him what he just said, he calls her a bitch and pistol whips her. And the gun goes off, blowing out the window to that car. But for the grace of God, Angela's not dead. She goes to the hospital because remember she had injuries she had to have taken care of. The defendant's caught, brought to her. She identifies him. This is aggravator number 2. Did we prove it beyond reasonable doubt? There is the judgment of conviction. Battery with a deadly weapon. He pled guilty to it. It is established beyond reasonable doubt. Is it a crime of violence? That's what it has to be to fit. It's the unlawful use of force or violence against the person of another. We know it was violent. She got hit in the head. She had to have stitches. That's violent. That is aggravator number 2. Go back to section 1 of your form, and you can check the box. There's the second aggravator. Proven beyond a reasonable doubt. We just need one in order for him to have to face the death penalty. Establish one. We've established the second one. Let's go to the third one. Now, keep in mind, when he did that, he had just finished parole. So what he did to Angela, he had just finished parole for Mr. Henderson. Then he gets arrested for Angela's, and you heard the testimony, he made bail. He made bail on the charges that he was facing for Angela. And what did he do? He learned from his behavior, right? No. It brought us to aggravator number 3. Now, the killing of Karen itself is not the aggravation. It's the way in which he killed her. It's how he did his dirty work. It is depravity of mind. There is a definition as to what depravity of mind is, and it includes to alter radically so as to make imperfect. Did the defendant alter radically as to make imperfect Karen? Now, when you're making that determination, understand that the mutilation, what he did to her, that can happen during, before death or after death. But the actual mutilation is beyond the act of killing itself. It is injuries and damage to her body that's not causing the death. It's beyond the act of killing itself. 45 stab wounds. We have to go through this to show how this is beyond the act of killing itself. You heard from the autopsy report, it's in evidence. You heard read into evidence the doctor who actually performed the autopsy, her testimony, Dr. Hollander. Blunt laceration trauma to the skin on the left side of her head. A knife wound to her back. 8 stab wounds to the top right side of her head. To the top right side. 8 stab wounds to the back of the neck. 8 stab wounds to the front of the neck. There was 1 stab wound behind her left ear. 8 stab wounds to the left breast. 8 stab wounds to the right breast. And ask yourself, this should be going through your mind, is this beyond the act of killing itself? 3 stab wounds to the abdomen area, 1 above the waistline that went into her liver, 2 on the left side of her abdomen. There's now the defensive wounds on her left arm and her right hand. He turned her into a pincushion, stabbing her 45 times. Going through those injuries to distinguish between those that caused her death and those that are beyond the act of killing itself, what was the testimony from the doctor? Could you tell me what your internal examination disclosed that's of major importance in this particular case with reference to any of these knife wounds? This was the testimony read in of Dr. Hollander. She's the one who performed the autopsy. Answer: yes, the knife wounds in the front of the neck penetrated into the muscles of the neck, and 1 penetrated in between the 3rd and 4th cervical vertebrae, going in between the 2 and reaching the spinal cord, causing hemorrhage. So 1 to the front of the neck gets her spinal cord. The stab wound to the chest on both sides penetrated into the lungs. There was also 1 stab wound in the back which penetrated into the lung from the back. The stab wound of the upper abdomen penetrated into the liver. Those were the major internal injuries. Now the cause of death. The information about the wounds, both external and internal, that you have given to us, was the information sufficient for you to render an opinion as to the cause of death of this individual? Answer: yes. And what was the cause of death? Listen to specifically what she says and put it in context with the other things that she said. The cause of death was multiple stab wounds of the neck, the chest, the back. Could any of those alone, or did all of them together cause the death? All of them together caused the death. That's referring to the injuries that she just indicated were the cause of death. The neck, the chest, the back. Was the cause of death homicidal in nature, in your opinion? Answer: yes. Would you exclude accident? Answer: yes. The injuries to the neck in the front, she testified to. The injuries to her chest. The injury to her back. Those are the cause of death. Now, to alter radically, to make it perfect, must be beyond the killing itself. What was beyond the killing itself? You heard about the defensive wounds. Now someone puts their hands up. There's a defensive wound on her right hand. There's a defensive wound on her left shoulder. Those don't cause her death. That's her just trying to survive through the night, to make it to the next day. Non-vital injuries beyond the act of killing itself. The top of the page says the other stab wounds penetrated into muscle. This is the doctor's answer. Into muscle which caused hemorrhage, but did not penetrate into any vital organ. For instance, all the stab wounds on the back of the neck, on the top of the head, only penetrated the skin, did not go into the head. Those didn't kill her. Those are injuries beyond the act of killing itself. What did not kill her? Well, we just heard the doctor say the top right side, 8 up to her head. 8 to the back of her neck. Defensive wound on her left arm. Defensive wound on her right hand. Cut to the back of her ear, abdomen. Those are the injuries beyond the act of killing itself. And then there was also this. Look at that diagram, ladies and gentlemen, and ask yourself, where's her abdomen? That's her belly button. Where's her abdomen, and where's that injury? Now, I'm not a woman, and I'm not trying to offend any of the women on this jury, but I dare say that if you had something, or a woman had something stabbed that close to her vaginal area, she'd probably say, yeah, that's not my abdomen. And we understand that it didn't go in directly. They had to shave her pubic hair in order to be able to show where the wound was. That wasn't her abdomen. Expert testimony, instruction number 22, it's in your packet. And I say this because I want you to put in context the testimony you heard from Dr. Coates. And later on we'll talk about Dr. Reuter. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. Dr. Coates said that was her abdomen. That was not her abdomen. And the actual autopsy report, which is in evidence that you have that you can read, says stab wound 28 was just above the left labia majora and penetrated into the soft tissues of the external genitalia to a total depth of approximately 2¼ inches. It entered outside, and when it went deep inside, made it there. Well, what's the big to do, right? Abdomen, non-abdomen. Ask yourself, is that altering radically? Is that making imperfect? Is that beyond the killing itself? How degrading to put a stab wound on a woman's body like that. That didn't kill her. That's depravity of mind, ladies and gentlemen. That's what she looked like before he got his hands on her. That's the radical altering that occurred after the defendant got his hands on her. Lethal and all the non-lethal injuries. All the acts beyond the killing itself. And remember, this is just barely a month after pistol whipping Angela. While he's out on bail, facing those charges. Has he changed? And that's after he just got out of custody for what he did to Mr. Henderson. That's your verdict form. Again, the third aggravator on the verdict form is Section 1, depravity of mind. Now, it gives you instructions from Sections 1 to go to 2 or go to 3. Look at those instructions, and it says here, if you answered yes to any of the above aggravating circumstances, go to Section 2. Well, the answer is yes as to all 3 of those aggravators. So you go to Section 2. Section 2 of your verdict form, you've got it there. That's the mitigation. Those are all the things that are put forth as possible mitigation. Something you can consider in determining what's the appropriate punishment. Now, instruction number 8. The defendant has alleged that certain mitigating circumstances are present in this case. Just because it's in the packet doesn't mean that that's a finding that those are mitigators. You decide if it's a mitigator or not. Because whether a mitigating circumstances or circumstances are found to exist is your decision. Just because it's said to you doesn't make it yours. And let's go through some of these and ask yourself, is this really a reason why his punishment should be reduced? Some reason why he should get less than the maximum punishment for what he did to Karen? Because he started using marijuana in the past for self-medication? I'm confused. We're going to give a benefit, a mitigator, a benefit for criminal behavior. Because not back in 1986, smoking marijuana, that's a crime. And why are we going to reduce his responsibility because he started smoking marijuana? There's a lot of other ways to deal with the problems that he had, or the difficulties in his life. Going to criminal behavior and smoking drugs is not a reason to reduce his responsibility. Well, John Valerio has been incarcerated in the Nevada Department of Corrections for 31 years, as he should be. How could the punishment be a means to reduce the punishment? How could we possibly say the fact that he's been in custody because of the murder he committed is a reason to give him less? He should be in prison for 31 years for what he did to that woman. Now, there's a list. I think there's about 21 alleged proposed mitigation from defense. You heard the instruction from the court. It's not the mere number of aggravating circumstances or mitigating circumstances. I mean, the state could have 21 aggravators and the mitigation could just be 3, or the inverse. It's not the number, it's the weight that you assign to it. It's the weight in your discretion that you give to those. And then we get to this, the alleged mitigation. Defendant John Valerio has redeeming attributes. Lacks characteristics of mental illness or psychopathic traits and has developed into a pro-social individual who is not at risk to himself or others, according to Dr. Wright. Now, take into consideration what you learned about Dr. Wright when you make the determination that that's not a mitigation. Because you can reject expert testimony. I read that instruction a moment ago. And ask yourself, what did Dr. Reutemann even do in this case? I mean, what did he do? What's his opinion based on? A questionnaire. He said, much like someone goes to the doctor, a medical doctor, and fills out a questionnaire about their history, their medical history, that's what he did. What do you do after that? What tests were run? If I go to the doctor because I'm having heart palpitations, right? I got problems with my heart. The cardiologist says, let's ask some questions. Let's get a medical history. Is this in your family? Have you had other things that have shown up in your health, right? That's understandable. Then they stick me on a treadmill, shoot an isotope through my arm, and take a picture of my heart to see what's going on. But beyond that, they'll actually have me put a monitor on my heart and check it for 24 hours and say, hey, what's going on with that heart? And then after that, let's do another stress test. Let's put you on that treadmill again, and let's do an echocardiogram. See, that's what you do to figure out what's going on. You test it. You don't just do a questionnaire. Ask the very person who has all the motivation in the world to skew the evidence in his best interest, and leave it at that. Well, he did talk to mom and dad, I understand that, and that's appropriate. But you remember when he was on the stand, Mr. DiGiacomo asked him, did you talk to anybody else? Did you talk to the people that he allegedly helps in prison? Answer, no. They're here to tell you, this doctor's here to tell you what the status of this person is, and it's all based on a questionnaire and a statement from the defendant. He was asked specifically, did you look at the criminal history of the defendant prior to the killing of Karen? Answer, no. Did you look at the facts of the actual killing of Karen? No. And this is really important. He admitted on cross-examination in another case, the Belcher case that I prosecuted, where he admitted he keeps things out of his report that could be bad for his client. And go back to that instruction about experts and ask yourself, do you need to rely on his testimony? Or can you reject it? A questionnaire. That's not. So you're in your verdict form because you've determined the existence of aggravators, you've determined the existence or the lack of the existence of mitigators, and then you have to weigh. That's that balancing that we talked about. You weigh. If the aggravation and the mitigation, you put them up. If the mitigation does not outweigh the aggravation, he is eligible for the death penalty. So, in Section 3, in the balancing, the aggravating circumstances or circumstances outweigh any mitigating circumstances or circumstances. When that weighing process is done, when you found that, then he's death eligible. Then you get to consider all the evidence in the case to make determinations to what's the appropriate punishment. That's Section 4. Those are the options. And think of those options that you've got here. Option number 1, life with the possibility of parole, with eligibility for consideration of parole beginning when a maximum of 20 years has been served. In opening statements, you were told this is just to give him the hope of the possibility of parole. You were told, whatever you do, he's not walking out that door. That's what you were told. Ladies and gentlemen, that's simple math right there. He's been in prison for how many years? 31. Almost 31. Possibilities after 20. If you select this, he is immediately eligible to go to the parole board. He might not walk out that front door, but he can walk out the door to go to the parole board's door. 11 years after eligibility. So the possibility of him walking out that door The parole board door is present immediately. Is that appropriate for what happened to Karen? Is that appropriate when you consider everything about the defendant? That is not appropriate. What is appropriate is the maximum punishment under the law. It was appropriate in 1986 when he did this to Karen. It was appropriate in 1988 when he was convicted, and it is appropriate today. That's what he deserves. That's what he earned, and we ask him to give it to him.